Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorian Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, everybody, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, and why you're even doing it in the first place. I really don't care. I'm just glad you're doing it here right now with me, Legal Vices, or at least just in the same room, because we're all here on the same channel. Welcome. I'm glad to have each and every one of you here with me today as we look at part 2 of this 58-page love letter written by Sarah Boone to the judge handling her case. Now, if you missed part 1, never fear, it's not necessary, but I do recommend you go back into the playlist and watch part 1. It was 2 days ago, I believe. Watch it. It's great. Because the reason it doesn't matter is because this 58-page letter is actually a collection of several letters, sort of a Sarah Boone anthology, if you will. So you're not missing much. We're going to be starting today at the beginning of one of the many letters in the Sarah Boone letter anthology that she submitted to the court a while ago. I am just happy and thrilled we're here. We watched the hearing yesterday. She's got another hearing coming up on Friday dealing with issues of taking possession of physical copies of her evidence and whether or not she will be allowed to sit in on her hearings without handcuffs and shackles. But also on this Friday is a Karen Reed trial. A hearing on the motion to dismiss the case because of the 4 or 5 or possibly even 6 jurors that have come forward and said that they found her unanimously not guilty of murder in the What was that? Wow. I think I opened up a second throat there. Unanimously found her not guilty of second-degree murder and fleeing the scene of an accident involving injury or death. So Friday, if it's live, we'll be covering the Karen Reed trial. If it's not live, I don't know what we're going to do. but stand by. And then early next week, we'll do the Sarah Boone trial, the hearing. All right, that is pretty much the run up to what's going to be happening today. Don't go anywhere because we have our housekeeping stuff. And I had someone suggested that we do something here that for some reason, I'm just dumb and never thought of before. Because I know a lot of people, why does my hat look like it's on crooked? It's not. It's on perfectly straight. I guess it must be the angle of the camera. What is wrong here? This is just, nothing's right. That's going to bother me for the rest of the damn day. Whatever. All right, let's do this. Sorry, OCD is taking over. There's nothing I can do. All right, that looks like that fixed it. Whatever was wrong, just taking the hat off and putting it on again seems to have done the work. Now I forgot what I was saying. Oh yes, a good idea. Somebody suggested in a comment that I had never thought of before. I don't know why I never thought of it before, but I didn't. So now I have. A lot of people, like I said, they complain that, you talk about nothing. You do all this housekeeping stuff and you just do a little chit chat and you don't do anything important. And then like later on, 5, 10, 15 minutes later, whatever, you get into the meat of what you're talking about today. And they suggested that I have like a swipe screen or a buffer or some sort of interlude so that when people scroll through, they can see, aha, there's the interlude that separates the beginning chit chat, the crowd warm up, if you will, the fellowship and philosophizing from the main subject that's being discussed. And I thought that was a very good idea. Why I had never thought of that before, I'm not quite sure. So I will have to develop something, some sort of swipe screen, some sort of interlude, some sort of intermission, if you will, to separate the beginning from the main part, from the introduction to the main part. But yeah, there we go. Let's see. We've currently got 177 people here waiting for us to get into this letter. This 58-page letter. We're starting on page 17 today, so we're probably going to have at least 2 more episodes after this. 177 people here and only 81 likes, like 90 of you, nearly 100 of you have not. Okay, now it's 194 viewers and 81 likes. 113 of you haven't done your job. Get down there and hit that like button, people, because we are just getting started, and you don't want to take your eyes off the ball once we get rolling. So now is your time to get it out of the way. And you people on replay, do it too. Hit that like button, hit the subscribe button. And if you have hit the subscribe button, make sure you are still subscribed because YouTube likes to delete people. And then, and only then, only if you have hit that like button and only if you have subscribed or made sure you're still subscribed, should you go over and take our like and subscribe poll of the day. Oh, for the first time in a long time, we actually have 10 more votes than we do 10 more likes than we do votes. That's a change. So get down there and hit that like button, hit the subscribe button, take our like and subscribe poll. Today's like and subscribe poll is simply Sarah. Should have killed him smother time. See what I did there? A little pun. Should have killed him smother time. Sarah Boone, avoid danger of suffocation. There wasn't enough room. See, I wanted to be like a warning. You've got a limited number of characters. I wanted to have it like, due to danger of suffocation, stay away from Sarah. But, Sarah, avoid danger of suffocation. Sarah, the roach, suffocation, no breathing. Okay, so that's 9% of you. So that means at least 9 of you are Papa Roach fans. Suffocation, no breathing. It's part of a Papa Roach song, or maybe you just stabbed that for no reason. But so far, the faraway leader is Sarah, has a prison nickname, Smotherfucker. So that's where we are. Suffocation, no breathing, right? Yeah, okay. There we go. Those are your choices for the like and subscribe poll. Just choose one of them. I don't really care what you choose. We'll get to it later. We'll check back in an hour or so and see how it did. We have an even 200 people watching us right now. All righty, people. It's time, he says in one of the Buffer brothers. It's Bruce Buffer that does the it's time, and Michael Buffer. Is it Michael Buffer that does the boxing? Let's get ready to rumble. It's Michael Buffer. It's the Buffer brothers. How would it be to be rich as hell? Because you say, let's get ready to rumble, and your brother is equally rich as hell because he says it's time. Hey, if you got a thing, go with it, man. Nothing but respect and jealousy on my part. Cut my arm, bleeding. Hey, there we go, Les. We got another Papa Roach fan here. All right. Jimmy Buffer. No, it's Jimmy Buffett. He's dead. All right, that's it. That's our. Okay, here's our temporary. Let's have a temporary screen swipe, shall we? This is the only thing I've got to segue from the introduction part to the main part yet. I promise I will have something less offensive sometime in the near future. But until then, people with ear pods, this is your ear pod warning. I suggest that you take your ear pods out for the next 21 seconds. And those of you that know what the ear pod warning means, this is the only thing I got for a swipe scream. So here we go. Let's get into the meat of the show today. All right, there's our temporary swipe into the fading into the movie into the meat of the show today. Invasion of the Body Snatchers, one of the greatest movies you'll ever watch. Rest in peace, Donald Sutherland. All right, Karen, and for those of you that are going, oh my God, my ears! I told you if you have earbuds in, take them out. And before we get going, we do have our very first super chat of the day. Unhung hero Samsonite, no breathing, video while I'm bleeding. Oh, hey, that's pretty good. I like that. Do we need to make a riff on a Papa Roach song for Sarah Boone? Is that what we need for the Sarah Boone trial? A riff on a Papa Roach song? Oh, I'm feeling the AI music coming on. I may yet do. I like that idea, Unhung Hero. Thank you so much for the inspiration there. Ooh, gotta be careful. All right. Well, this is a good reminder. If there's something you have to get off your chest, you want noticed, you want read, you want addressed, make sure you super chat it, because that is guaranteed that I will see it and I will read it and I will address it. Otherwise, I just kind of do what I have to do, and I try to look for amusing things here in chat. But when it's a reading heavy day like today, I don't get to spend a lot of time looking at the chat. But I do notice a few things, and I do bring them to the attention if I think they're particularly noteworthy and witty. And Yoda is just joining us. Yoda, one of my emotional support potato pig dogs. Strawberry's already over here on her little throne. So we are now $98 away from unleashing the potato pig dog cam. We are 1 day into our new streak. We had to reset because we didn't quite make the goal. Let's see if we can get a 2-day streak on the goal. We have to unleash the goal. Are we going to unleash the goal? Let's find out if we're going to unleash the goal as time goes on. All right. I think we got everything out of the way. Yeah, don't mind me. I like to ramble. And all right, that's it. Super chats will be read as they come in. If we reach the goal chat, then we unlock our emotional potato pig dog support cam. And until then, let's just get on with the show. Now, maybe I should do the swipe again, because I delayed it another couple of minutes, because that's how I roll. All right, here we go. Page 1. It's actually page 17, but this is page 1, because as I said, it's sort of a Sarah Boone anthology, her greatest hits, if you will, or maybe it's just like her only hits. Maybe it's her first album, we'll call it. West Florida statute, okay, and annotated, blah, blah, blah. Discovery. She's quoting law here, people. Notice of discovery. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these rules, including the taking of discovery, depositions, by filing with the court, and serving on the prosecuting attorney a, quote, notice of discovery, end quote, which shall bind both the prosecution and defendant to all discovery procedures contained in these rules. Well, paragraph B, prosecutor's discovery obligation. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control. ... aka ellipses. Well, that was 1A. God, she's just quoting law like a motherfucker, isn't she? A list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact, evidences, similar fact evidence to be presented at trial under section 90.4042 Florida statutes. Paragraph B. You know, she could have made this a little easier if she just would have quoted the relevant statute like she did up here. Just put, you know, the Florida Rules of Criminal Procedure 3.220A, you know, through whatever the hell the last number is. She doesn't have to quote this because I guarantee you the judge has a copy of them on his desk in his office, probably has another copy on his desk in the courtroom, and has a bunch of paralegals or court clerks at his beck and call that are intimate with the details of these rules. Well, B, paragraph B. The statement of any person whose name is furnished in compliance with preceding subdivision, the term statement as used herein here's our definition of statement. The term statement as used herein includes a written statement. Well, that would be a statement, wouldn't it? Made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. I'm trying to make the recitation of a stupid rule of procedure sound really interesting. It's hard, but I'm trying. I'm trying. Work with me here. Act entertained. The term statement is specifically intended to include the term. Well, sorry, I almost read the same line twice. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those reports are compiled. Notes are considered word perfect. I'm old. How many of you, by a show of hands, remember word perfect? Word perfect, the precursor to Word, basically. It was a competing word processing program, Word Perfect, which was preceded by Word Star. If anybody remember Word Star. All right, that's a little bit of a diversion there for all you olds in the chat. What I meant to say was notes are considered work product, not word perfect, work product. And work product is not discoverable. So then if I write a report, that report is discoverable to the other side. If I take notes and then I prepare the report from my notes are my work product. That's what I did as work to prepare for the formal report. So those notes are not discoverable as work product. C is for cookie. That's good enough for me. My son, that's a Pavlovian thing. I apologize for me, the 55-year-old man singing Cookie Monster's C is for cookie song. It's just Pavlovian. My son's name starts with C, so every time I would see a C or watch him write his name or say something, I would just start with the C is for C. Any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in the police reports or report summaries, together with the name and address of each witness to the statements. Fine. Again, I've mentioned this before. I think last time we read these letters. How many of you in your entire life have written by hand, written out a line and put a hyphen in your writing? I would just, if there's not enough room to write substance, I would just start substance on the next line. Or like defendant, like here, like DENT, I would probably squish it so it all defendant all fit in one line. This woman has put 3 hyphenated line breaks in a 6-line paragraph. That is wild. I've never seen it, and she does it all the time. There's another one. It's every time I see it, it baffles me, and I have to pause a little bit because I've never seen anything like it. I've never had a hyphenated line break in a handwritten document in my life. Legal-minded Karen Cole says, I don't wait, I do. That's how I was taught. Where do you go? Legal-minded Karen Cole says, in writing, I do. I even have my my Word, my Microsoft Word set to not hyphenate line breaks. I hate it. I don't know why. I swear. Anyway, D, any written or recorded statements and the substance of any oral statements by a co-defendant. Dun, dun, dun. There are no co-defendants in this case, so I don't have to hit the button. Those portions of recorded grand jury minutes that contain testimony of the defendant. It almost makes me want to hit that dun, dun, dun button after every sentence, but that would get old quickly. Paragraph E. These are things that are part of the discovery here. Those portions of recorded grand jury minutes that contain testimony of the defendant. F, any tangible papers or objects that were obtained or belong to the defendant, including empty bottles of wine, suitcases, and the like. G, whether the state has any material or information that has been provided by a confidential informant or a prison snitch. H, this is starred. All right, ladies and gentlemen, Sarah Boone has starred paragraph H. I believe that means she deems this to be a particularly important paragraph. Let's see what it says. Starred paragraph H. Whether there has been any electronic surveillance, including wiretapping on the premises of the defendant or of conversations to which the defendant was a party and any documents relating thereto. Hadn't heard of any wiretapping. Don't quite know why that was deemed important enough to star, or maybe she just got bored and, like I do, you draw pictures in the margin occasionally. Paragraph I, whether there has been any search or seizure and any documents relating thereto. If she doesn't get to the point and stop quoting law, I'm going to have a search and or seizure. More likely the seizure. Paragraph J, reports or statements of experts made in connection with the particular case, including the results of physical or mental examinations and of scientific tests, experiments, or comparisons. Oh, sweet Jesus. Oh my God, it goes on and on. Oh my God. Oh dear, this is terrible. I didn't know I was going to inflict just a handwritten transcription of the Florida Rules of Criminal Procedure and relevant statutes. Yes, the government and every major corporation all have us wiretapped. She's talking about her prison calls. Done. Yeah, during her hearing, she kept saying, my prison calls are all out there in the public. I haven't seen one of them. So, yeah, she thinks everybody's spying on her, says Paige. Dun, dun, dun. Oh, dear. All right. Physical or mental. Okay. K, any tangible papers or objects that the prosecuting attorney intends to use in the hearing or trial and that were not obtained from or that did not belong to the defendant. Any tangible papers, objects, or substances in the possession of law enforcement that could be tested for DNA. M, whether the state has any material or information that has been provided by any informant witness. There's our prison informant. If the court determines in camera, that means in chambers, that any police or investigative report contains irrelevant, sensitive information interrelated with other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or activities, the court may prohibit or partially restrict the disclosure. The court may prohibit, it says here in paragraph 3, the state from introducing into evidence any of the foregoing materials not disclosed so as to secure and maintain fairness in the just determination of the case, of the cause. All right, so yeah, if you didn't disclose it, you don't get to bring it into court. That's what that rule is saying. But what on earth is member for 9 months Pastor Flash saying? Pastor Flash is saying instead of a swipe screen, you can create chapters/segments after a stream is done. Simply add timestamp to description. I sent an example. Oh, I know how to do that. What they're talking about is like, so when you people are watching on the replay crew, they like drag, the cursor across the timeline to like fast forward through the video, and if they see the stream, if they see the swipe stream, the screen, then they know that the preamble stuff has ended and the main part of the show has started. They want like a visual cue so that they can drag it, they can drag along the line, and they go, aha, there's the swipe stream, there's the swipe screen. Now we know he's starting with the show. I know all about the chapters and things. But that's so we're talking about two different things here. But thank you very much for your concern. Unhung Hero with the $2 says, just stuff Jorge in a suitcase. I'm sorry, it's George. I know it says Jorge, but he calls himself George. Well, he called himself George. It's past tense. Stuff George in a suitcase. This is his final straw. Dun, dun, dun. More lyrics. Jeremiah Jordan with the $5. So is Sarah's time running out? Oh, we got a bunch of comedians here today, don't we? Thank you, everybody, for that. We are marching steadily forward towards the Emotional Sport Pig Dog Cam Day 2, keeping the streak alive, if you can call one a streak. The court may prohibit the state from introducing into evidence any of the foregoing material not disclosed so as to secure fairness and maintain fairness and in the just determination of the cause. For as soon as practicable after filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant. So you have to, this is what we talk about when you talk about the prosecution has an obligation to disclose exculpatory evidence to the defendant. If the cops go, holy shit, we have this evidence that proves he didn't commit this crime, let's hide it, which is kind of what we saw in the a version of this is what we saw in the Alec Baldwin trial. With like, oh crap, we've got some documentation here that might weaken our case, let's bury it. You can't do that. You're absolutely not allowed to do that. So you have to disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant or as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. Okay, so again, they're saying you can't hold it and go, you didn't disclose your stuff, so we don't have to disclose ours. You still have to disclose it, even if the defendant hasn't met their burden. Bernice Conklin, member for 13 months. Thank you so much. Hi, Jeff. If nobody's told you lately, you are so appreciated. Thank you. Well, you're very much appreciated for saying that I'm appreciated. I appreciate that, Bernice Conklin. Thank you very, very much. I appreciate you. And I appreciate each and every one of the 323 people that are here now. So thank you very, very much, people. All right, let's get back onto this as soon as I stop Yoda from licking Strawberry's ear. Hey, let's not do that. Let's not do that. Yoda, unless you're paying the $150 vet bill, don't do that. Love you, buddy. All right, defendant's obligations. Whew. All right, we got through the prosecution's obligations. She's not letting us off the hook. Now she's going to quote even the obligations that she has. Why she's quoting her obligations to the judge is beyond me. But before we do that, let's look at what Jill Ems has to say with a $5 super chat. I'm confused as to why he got into the suitcase in the first place. And how did he know he would fit? Well, I don't know if he knew he would fit before he did it. He certainly knew he would fit after. And as to why he got into the suitcase in the first place, I'm going to blame alcohol on that one. She said they had a bottle of wine. They had shared a bottle of wine. I'm calling horse shit on that. I'm pretty sure they had many bottles of wine. But eventually it seems that alcohol is the reason that he got into the suitcase and allowed himself to be zipped up. Now, for those of you keeping score at home that may not be too intimately familiar with this case, She's admitted to zipping her child up in a suitcase before. So keep that in mind. This isn't a one-off thing. She has previously zipped up her own child in a suitcase. Oh my Lord! Sweet baby dumpster Jesus. We have a Hey Joe. Woo! Hey Joe is in the house with 5 Legal Vices memberships.
Release the hose.
Is not here yet. It's coming up. You have put us substantially along the way. I meant to do this. Hey Joe, 5 Legal Vices memberships. Bifron's got one. Mexican Vader got one. KLF got one. Jingleberry, hey Jingleberry, what's up? Jingleberry got one, and Ralph 707 got one of those memberships. Make sure you give Hey Joe a super special thanks. All right, that is awesome. Oh, Adair doesn't want to be ignored, so Adair is mentioned with the 3-month membership to the Clean and Sober crew. Thank you so much very much, Adair. What a lovely little geek cat. Megan was replaying parts of the Karen Reed trial. She doesn't remember the expert that studies forward. Well, I object to your use of the term expert to describe that police officer's qualifications. Well, congratulations, people. I think I've just become the first person in history to choke on air. Yes, he was just a lowly little police officer who studied forward. So yeah, I object to you're referring to him as an expert. But yes. All right. I literally just choked on air. Oh Lord. All right. Well, as I said, Sarah has graced us and gifted us with a better understanding of what the prosecutor's duties as far as disclosure are concerned are. Why she's telling the court what she has to do is beyond me, but let's find out. Just for shits and giggles, let's find out what Florida requires the defendants to do, shall we? D, defendant's obligation. If a defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of discovery deposition, the following disclosures shall be made. All right, here's what the defendant has to do. Strawberry's hyperventilating. Nope, it's Yoda. Within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor. This is kind of what they talked about at the hearing yesterday when they were setting all of these dates. We're going to give you your discovery today. You've got 2 weeks to give your list. After that, there's another period of time to respond. Then we have the objections. This is what they're talking about here. Within 15 days after the receipt, but again, why this is in her letter to the judge is effing beyond me. After receipt by the defendant of the discovery exhibit furnished by the prosecutor pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing. And again, she's got 2 weeks to do that according to the schedule that came down during the hearing yesterday. When prosecutor subpoenas a witness whose name has been furnished by the defendant, except for trial subpoenas, the rules applicable to the taking of deposition shall apply. Oh, be still my beating heart. This is just thrilling, isn't it? Within 15 days after receipt of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit, which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and material that is in the defendant's possession or control. Oh, shit. This is going to be exactly everything we just read, but with the word defendant and prosecution flip-flopped. This is literally what it's going to be. There's going to be like A through M and all this other shit. And it's just going to be the same thing we read with prosecution and defendant flipped. Oh God, I can't. Is Bush being disruptive in chat? Yes. All right. Here's what has to be done. This is the following material that is in the defendant's possession or control that must be done. Oh, God. The statement of any person listed in subdivision D1A other than that of the defendant. 2, reports of statements of experts that the defendant, oh God, this is it. The defendant intends to use as a witness at a trial or hearing made in connection with a particular case, including the results of physical or mental examinations and of scientific tests, experiments, or comparisons. And 3, crazy Sarah Boone train. Sorry, any tangible papers or objects that the defendant intends to use in the hearing or trial. Perhaps I have lost my mind and I'm the one that's on crazy train. The prosecutor and the defendant shall perform. Oh, that's all? Well, that was short. Sweet. But I don't think that's where it ends. We'll find out. The prosecutor and defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. I like this. In a manner mutually agreeable as ordered by the court. I order you two to agree to this. Or, is this agreeable? Well, I order it to be agreeable. That's sort of kind of almost mutually exclusive. Agreeable, both parties agree as the court ordered. All right. The filing of a motion for protective order by the prosecutor will automatically stay the times provided for in this subdivision. If a protective order is granted, the defendant may within 2 days thereafter or at any time before the prosecutor furnishes the information or material that is subject of the motion for protection order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. Well, who cares? The restriction of this better not just be like another, God, what would that be? 35 pages of just quoting laws. Can we get back into the telling the judge how the judge is doing a shitty job, please, Karen? You're boring all of us to tears by just quoting the stupid Florida rules of criminal procedure and statute. Restricting disclosure. Now I went from Papa Roach to Ozzy. The court, on its own initiative or on motion of counsel, shall deny or partially restrict disclosure authorized by this rule if it finds. Okay, here's how we can restrict or deny disclosure of certain things. If it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance. This whole entire case is an unnecessary annoyance. Perhaps we should deny this whole case. Or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure to either party. Additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. The court can pretty much do anything it wants in the name of justice. Sanctions. Here's what happens if you're a naughty boy or girl, and the judge has to rap you on your knuckles, on your financial knuckles. Sanctions. If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, may grant a continuance, grant a mistrial, prohibit the party from calling a witness or disclosed witness not disclosed, or introducing in evidence the material not disclosed, or enter such other order as it deems just under these circumstances. Florida woman, you can do it. Oh, Lordy. Here we go. Okay, all right. This is page 24. How the frick long does this go on? Oh, thank God. It only goes on for 2 more pages. Sweet. All right, let's buckle yourself in. The throat's getting a little dry. Need a sip of cool sparkling, not like sparkling bubbly water, but just water that happens to sparkle in the crystal glass. It's just cold, still water. Cool water. Willful violation by counsel or a party not represented by counsel of an applicable discovery rule or an order issued pursuant thereto shall subject counsel or the unrepresented party to appropriate sanctions, to a solid spanking. By the court, the sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate. I still think that a good sound spanking might take care of this. Just take Sarah over your knee and just give her a good whacking, and then the prosecutor too for not taking off his raincoat. Every request for discovery or response or objection, including a notice of deposition made by a party represented by an attorney, must be signed by at least one attorney of record as defined by Florida Rule of General Practice and Judicial Administration 2.505. In the attorney's individual name, whose address must be stated. A party who is not represented by an attorney, that would be the intrepid Ms. I almost said Ms. Reed. That would be the intrepid Ms. Boone. A party who is not represented by an attorney must sign the request, response, or objection and list his or her address. What about a they-them address? The signature of the attorney constitutes a certification that the document complies with Florida Rule of General Practice and of Judicial Administration 2.515. The signature of the attorney or party constitutes a certificate that the signer has read the request, response, or objection, and that to the best of the signer's knowledge, information, or belief, formed after a reasonable inquiry, this is what the person who's signing the disclosure document says. That to the best of their knowledge, it is consistent with these rules and warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. Modification. I guess that's modification. Faith argument for the extension, modification, or reversal of existing law. Again, here it is starred, not interposed for any improper use or purpose, such as to harass or to cause unnecessary delay or needless increase in cost of litigation. All right, sorry, that harass thing, that is also Pavlovian from The Princess Bride, when Andre the Giant is writing poetry, and he's like, to harass. Every time I see the word harass, I have to do it in Andre the Giant voice. I apologize. Not unreasonable or unduly burdensome or expensive given the needs of the case and the importance of the issue at stake in litigation. Pre-trial conference. Oh, been there, done that. This is Sarah teaching us. She ain't teaching us crap. She's just teaching us how to transcribe. Oh my Lord. By Franz, you have never seen The Princess Bride? Wow. Dang. Pre-trial conference. The trial court may hold one or more pre-trial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing. She can't waive that in writing, by the way. She can't say, I don't want to come to the trial anymore, because she is also her own lawyer. And her lawyer, at least her attorney must be present. And because her attorney is her, she must be present. Unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. The court may, oh, thank God, this is the end. Oh, fuck me, it's the end. Phew. The court may set, and upon the request of any party, must set a discovery schedule, including a discovery cutoff date at the pre-trial conference. End page 10. Oh, my Lord, have mercy. That was painful. Thank you all for bearing with me on that little unpleasant journey down the relevant procedural things. Wow. All right. Let's take a look at what we got going here right now. 35. We are 65 away from the emotional support potato pig dog cam. Will we reach the goal 2 days in a row? Let's find out. Just watching. Yes, Princess Bride is a classic. I can't believe there's still people out there that haven't watched it. As always, the chat is talking about things that have nothing to do with what I'm discussing, so I don't even know what the chat's talking about. Did you show the advertisement for an attorney? Pretty artistic. We'll do that at the end. At the end of this letter, whether this is today, tomorrow, or the next day, we'll go over her advertisement for her new lawyer. Well, Les has never seen Princess Bride either. All right. I derail because of the movie thing. Well, that's kind of what we always do. And I know that Jeff turns into Mike every now and then. Pre-trial. We don't know what you're talking about. Okay, well then it's mutual. You know, you don't know what I'm talking about. I don't know what you're talking about. I just, as I said, I'm just happy you're here. All right, here we go. Will you answer the advertisement, Jeff? I cannot. One, I'm not in the U.S., and two, unfortunately, don't happen to be licensed in Florida. And unironically, I'm no matter what I make in Super Chat streaming the trial, I will make more than her lawyer. So win. It's a win for me. I would need a cut in pay. It would be a huge cut in pay if I were to go and take care of that, because I would earn zero. If I get a single Super Chat during the trial, I would have made more money than her lawyer. Okay, well, your hat is slightly squint. It looks really weird. From a fellow ADHD OCD, you're right. Your wee quirks make me laugh. No, it's good. It was just it was positioned oddly at the beginning, but you know, it's a thumb's width from my glasses on either side, and because I'm kind of sitting askance to the camera here. If I look at the camera dead on, which is like right about this angle, things work. But you know, anyway, that's beside the point. That's not what we're talking about. Stop it! Just don't get me you know, off. Don't get me off being off track. I don't need to be off track from off track. No, man, he's not a fan. Talking about the YSL trial. We don't care about the YSL trial here. Keep it focused at least on this. You know, the if people want the YSL thing, they can go find the YSL thing. We don't. We don't talk about other things that are going on at this time, just out of principle. All right, that's just a thing, you know. Because then people go, oh, gee, what's that? And then they leave here, and that's what we're not doing. We like to keep the people here. So yeah. All right, here we go. Finally. Let's hear what. Oh God, there's quotation marks. This isn't even her talking. God dang it! I thought we were getting to some full-on Sarah Boone. Crap. That the individual shall have full protection in person and in property is a principle as old as common law. Be it has been found necessary from time to time to define how the exact nature of excellence of such protection. The hell does that even mean? Political, social, and economic changes entail the recognition of new rights, and the common law in its eternal youth grows to meet the demands of society. This, in very early times, the law gave remedy only for physical interference with life and property, for trespass, viet armis. Is she quoting Gideon again? Hang on. Thus, in very early times, the law gave remedy only for physical interference. Quotation marks. I spelled physical wrong. Physical. Let's get physical. Physical. Let's get into. Nope. Huh. I don't know what she's quoting from, but Google doesn't recognize it. Oh, wait a minute. Oh, this is from 1890. In Justice Louis Brandeis' Right to Privacy. Ooh. She must be really, really bored. She is quoting from Supreme Court Justice Louis Brandeis, The Right to Privacy, from December 15th, 1890 in the Harvard Law Review. Well, shit. See, Sarah's not dumb. She's read shit even I haven't read. All right. So, The Right to Privacy by Louis Brandeis from the Harvard Law Review in 1890. What the hell this has to do with anything, I'm not really sure, but thank you very much, Sarah. What is... Oh, I see. Not Vietnamese or Viet Army. It's Viet Armis. That's a tort. Right. That's like a trespass upon a person by force of arms. So, all right. Never mind. Damn, Sarah. She apparently has not, she didn't cite her source yet. We just haven't got to the bottom of it. Perhaps I just should have continued. All right. So let's get back to quoting Justice Brandeis from 1890. Then the right to life served only to protect the subject from battery in its various forms. Liberty meant freedom from restraint and the right to property secured to the individual, his lands, and his cattle. Later, there came a recognition of man's spiritual nature, of his feelings, and his intellect. Gradually, the scope of those legal rights broadened. The scope of those legal rights broadened, and now the right to life comes to mean the right to enjoy life, the right to let alone, the right to be let alone. The right to liberty secures the exercise of extensive privileges, and the term property has grown to comprise every form of possession, intangible and tangible. The Bouvier Law Dictionary, 2012 edition, or Justice Brandeis' Harvard Law Review article from 1890. Hey Joe, dropping the $1.99 super sticker, moving that potato pig dog cam ever closer to reality. Thank you so very, very much. Hey Joe with the suitcase. It's a suitcase super sticker. Thank you very, very much. And Jill M's, if she plays really dumb, would she get her 9th counsel? I don't think so. I think the judge is dead set at this point on going to trial under the idea of let's just get my part of this over with and then let the appeals court deal with this shit. If I were to put myself in the judge's head, that's probably what he was thinking. Jim, I'm allowed to put what I own into a suitcase. It's not my fault. He can't handle it. Yikes. Ms. Jax M is a new member. Welcome to the clean and sober crew. Ms. Jax M, so glad to have you aboard. Stick around for a while. I will try to amuse you. In the meantime, let's get back to some Sarah Boone, shall we? Oh, my Lord in heaven. Now we're going to the Declaration of Independence. No. Oh, no. We're going to the preamble to the American Declaration of Independence. Oh, God. Are we going to do the preamble to the Constitution next? Oh, shoot. I give up. I really do give up. All right, to help to help us get through these tough times, to help us get through to suffer the slings and arrows of the Sarah Boone missive to the judge, to help us get through and this would be a good education for those of you not in the United States that have never read the Declaration of Independence. I hope to God she's not going to quote the entire thing, but if she does, you'll get to hear the American Declaration of Independence. But to help us get through that, we owe a huge vote of thanks, a huge debt. We owe everything, as it were, to one brave soul in chat. D what in the house? D what? Release the hounds. D what has got us to that point right there. Put us over the edge to that thing that we like to call
Release the hounds.
All right, let's get this thing underway here, shall we? We've got like dead dog cam here. All right, the strawberry is moved, so we've just got the Yoda cam here. Here we go. Boop. Yoda, there's the corpse of Yoda, just laying on the floor right here next to me. All right, thank you so much. That makes a 2-day streak. We've hit the goal 2 days in a row. D what? Thank you very much for releasing the hounds. And Jill M's, she is trying to kill you slowly with word vomit. Hey, don't you be calling the Declaration of Independence in America word vomit, young lady. That's the foundation of Western civilization. Thank you, Jill M's. I appreciate that. All right, well, there we go. We've released the doggo cam. We have our emotional support potato pig dogs. Embrace the Yoda and let's settle in. Because this is a perfect time to take our midstream little griftathon here. We've got 388 concurrent viewers who are just going to join us here now to read the American Declaration of Independence as quoted by Sarah Boone in her 58-page love letter missive to the judge. Before we do that, though, just a quick reminder that we have 271 likes, so at least 111 of you haven't done your job. Get down there and do me that favor and smash that like button from here to kingdom come. And at least hit it an odd number of times. And make sure you've subscribed to the channel because we are moving northward, ever northward in our quest to get to 80,000 subscribers. We are very nearly there. We're approaching 80,000 subscribers. We are probably about 1,000 away somewhere. We are 825 subscribers away from 80,000. So please make sure you hit that subscribe button. And if you are subscribed, double check, please make sure you are still subscribed and take our like and subscribe poll. 311 votes on our like and subscribe poll. How are we doing today? 7% of you said Sarah Boone, avoid danger of suffocation. 12% of you have said Sarah Boone, the roach, suffocation, no breathing. 14% of you said should have killed him, smother time. And 66% of you, a full 2/3 of you, say Sarah has a prison nickname, Smotherfucker. All right, there we go. Tammy Fayette says, I tried super chatting emotional support pig dog once and YouTube wouldn't let me. All right. Well, YouTube's weird in what it'll allow and what it won't allow. All right. Well, there we are. That's the midstream grift. Do all the YouTube-y stuff and let's get on with it. Because, hey, this is the moment we've all been waiting for. Sarah Boone quoting the American Declaration of Independence, 1776. I wish I had some rousing patriotic music to put in the background. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted. How do you mess this up like this? Governments are instituted among men, deriving their just powers from the consent of the governed, We just get the, oh, come on. We just get that little bit. Lame. Well, we get more of the Florida Constitution. If you want to compare and contrast the Declaration of Independence with the Florida Constitution, let's do that now. No, Western civilization started when Jesus came over on the Titanic and founded the USA on the 4th of July. Exactly. Florida Constitution 2024. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty, in order to secure its benefits, perfect our government. It literally says that Florida is with they're grateful to Almighty God for perfecting their government. Oh no. Oh, Florida. That's a joke, right? Perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all. Do ordain and establish this Constitution. They just kind of stole and modified the U.S. Constitution for that. Oh Lord, I'm assuming this is the Bouvier Law Dictionary here. All right. In a completely non sequitur, she goes from the American Declaration of Independence to the Florida Constitution to the definition of client. Well, on a positive note, we're halfway through this letter. we're halfway through this letter, if that's of any consolation to anybody involved. Judge Kranick must be demented reading these. I'm pretty damn sure that he didn't read these. They're not motions, they're just ramblings. He goes, all right, court clerk, please make a copy of this and send it to the prosecution. Thank you. And that's it. I would be shocked if he, Florida's problem is Florida man, not Florida government. I would be shocked if the judge actually read this, other than like for giggles. Sadly, you can't sing the Florida Constitution preamble. Ooh. Is that a Schoolhouse Rock reference you just made, Janet Burris? Client, a person who relies on the professional services of another. The client of an attorney is the person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement, with the performance of service in reliance on a request for representation, or with a statement of representation on which the client relies. That raises the important question. So what? Bingo, says Janet Burris. All right. He did say he read all her letters during the hearing we watched yesterday, I believe. No, he said he did. He said he did. But did he really read all the letters? Oh Lord. All right. All attorneys owe a client. Oh, now here's where she's talking about where she's going to say that her lawyer's a piece of crap. These are her lawyer's duties to her, and I assume it's going to be followed up by, this is how he or she failed. All attorneys owe a client a duty of zealous representation, balanced by the obligation to serve justice and act as an officer of the court. That's a huge balance, to zealously represent and to act as an officer of the court. Attorneys also have an obligation to keep the confidence of a client at all times and to keep the client informed of all matters related to the client's interest. To inform the client of law related to the client's affairs and to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and the law. That's where that right there is where I assume most of the breakdowns between her and her 8 lawyers occurred. I know one of them conflicted out, but probably she was asking them or forcing them or trying to do something to get them to act contrary to the highest standards of professional responsibility and to the law. Young black economist says she really only went to like 5 lawyers. Y'all doing her dirty by blaming her for the other 3. Well, in fairness, I know one of them conflicted out, the very first one, because there was a big conflict. She had an appointed lawyer and a public defender, and there was like this. All right, who's representing her? And the one that got paid's like, tell you what, I'll just step aside. The first one, that was just she conflicted out. She went. So yeah, there's been a couple. But yes, young black economist, I stand chastised because she really only fucked around with about 5 lawyers rather than the 8 that we keep accusing her of. All right. Fair enough. Thank you very, very much for bringing that to the attention. Attorney-client privilege, another starred section. Please check if Yoda is alive. I'd have to leave Yoda asleep because Yoda is really, really stupid and mostly deaf, I think. Either Yoda is mostly deaf or Yoda gets so caught up in like Yoda land that if I were to touch Yoda now, Yoda would freak the hell out. He would just be like totally startled and freak out. And I don't want to do that. That's mean. Attorney-client privilege. Let's learn about attorney-client privilege from Professor Boone. One of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communications between attorneys and their clients, thereby promoting broader, confident correspondence in accordance to the appropriate observance of the law and the administration of justice. Okay. Jeff gave him brain damage. No, Jeff saved him from brain damage. I could tell you the story of Yoda's rescue someday. But Yoda and Strawberry are brothers and sisters. We bought me and my girlfriend at the time. We bought Strawberry. We didn't buy Yoda. We went back about 5 months later to visit the owner, the breeder, and we saw that Yoda had not been adopted and Yoda was not doing very well. So we rescued Yoda. So Yoda was suffered for months from basically malnutrition. So there we go. Janice Morago Baldwin says, "Legal Vices, I promise I'll renew my membership when I get paid." Hey, do or don't, man. There's no pressure here. Don't worry about it, Janice. If you can, do. If you can't, don't worry about it. It's all appreciated. All right. Well, she starred Zealous Advocacy. Tell us, dear Sarah, tell us, dear Sarah, what is zealous advocacy? An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating these rules of professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefits the client while remaining faithful to the facts and the law itself. Well, see, that's where a lot of these things go wrong. The part about remaining faithful to the facts. It's like, yeah, well, what you want me to say and do doesn't really remain faithful to the facts now, does it? And then you get in arguments and then you get fired or you fire your client. Zealous advocacy is a requirement of the oath required by attorneys admitted to the success of the adversary system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never an inclusion of zealous advocacy. And the use of such crosses the line from acceptable forceful advocacy to unethical conduct, says Bouvier Law Library 2012 edition. Oh Christ! Now she's gonna accuse her lawyer of misconduct here, either directly or just by quoting what the dictionary has to say about attorney misconduct. Did one lawyer say she was pushing ethical boundaries and put irreconcilable differences so they wouldn't have to breach the privilege? I think paid one. Well, the lawyers have said there's a complete breakdown of communication. There's a refusal to communicate. There's irreconcilable differences. I think one of them alluded to something about being asked to do things. I can't. God, there were so many, not 8, but at least 5. As our up-and-coming economist informed us earlier. But yeah, I can't remember. There was something, one of them said something like that, if I recall correctly as well. Attorney misconduct. What is attorney misconduct, you may ask? 'Tis a very good question. And Ms. Sarah Boone is about to edumacate us. Attorney misconduct is a failure of an attorney to comport with the rules and accepted professional customs of the bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as a counselor and fiduciary of a client, or as a member of the legal profession. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. Most jurisdictions, as I understand it, have this clause here at the end. Is like even shit you don't do as a lawyer can get you in ethical trouble. It can be considered attorney misconduct. If you do something outside the scope of your legal representation that disparages or besmirches the grand practice of law and being a member of the bar, you can find yourself in trouble for doing shit that has nothing to do with your job. Just because you happen to be a lawyer. People go, that makes us look bad, you dumbass. Luke Smith with the Aussie $2 super sticker. It's a pear and a headband that seems to be embarrassed about something. Thank you very much, Luke Smith, for the super sticker. Oh, we already read the Jill Ems one. All right. Guess we're caught up. All right. Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or to sanctions, although a variety of forms of each exist. Misconduct may always be the basis for a client to remove an attorney from their duty of representation, as is any other cause for the client's loss of trust and confidence in a lawyer. ... ellipses, and the attorney's demeanor to determine whether a party's substantial rights were affected, ellipses, based on repeated or persistent objected to misconduct. The district court shall factor into its analysis that the notion by engaging in continued misconduct, the offending attorney has accepted the risk that the client's case may be influenced by said misconduct. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by objection and admonishment might not be curable when that improper conduct is repeated or persistent. Thank you again, Bouvier Law Dictionary. Oh my God, Duress. Why am I reading dictionary definitions? And why is 374 of you sitting here listening to me read, not the Black's Law is the standard law dictionary. Black's Law that's the pinnacle of law dictionaries. This is the Bouvier Law Dictionary. It's a lesser law dictionary. I'm reading you definitions from a lesser law library, and 376 of you are sitting here listening to me read definitions from a sub Black's Law Bouvier Law Dictionary. And occasionally you're paying me money to do this. This is the weirdest thing I've seen in quite some time. But you're not under duress. None of you are under duress. And you know how I know that? Because Sarah is going to tell us what duress means. And none of it applies to any of you that are sitting here listening to me read definitions from a lesser law dictionary. Duress, in case you're wondering, is an unlawful threat that limits the person's independence of judgment or action, and is any improper threat or condition, such as coercion, that limits a person's ability to think or act independently, and the presence of destroys the independence required of the party subject to. Ooh, my screen just flashed black. That was weird. In order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right is involved. In what? She's cut something out there. In order to constitute a voluntary consent. What the fuck? What? Okay, I guess she's talking about like agreeing to something under duress. She skipped some parts here. In order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose rights is involved. In addition, such person must be cognizant of their rights in the premises. Is she talking about the search of her house that it was under duress? I guess she's saying that, all right, whatever. In addition, such person must be cognizant of their rights in the premises. The consent must not be contaminated by any duress, coercion, and the government has the burden of proof. Habeas corpus. Habeas corpus. One of my favorite things in law. Seriously. Habeas corpus. A review of the lawfulness of any person's custody or restraint by a government official. It is a process of judicial review of any person's detention, whether by formal custody, incarceration, or continuing restraint by an official or agent of the government of a state or of the federal government. The right of review of custody by habeas corpus is a fundamental constitutional right. It is a bulwark of individual liberty being used to free people by courts without without legal authority or without having complied with the requirements of law. Habeas corpus is protected by the U.S. Constitution from interference. A defendant who has been confined for 30 days after their arrest without a trial shall be allowed a preliminary hearing upon application. Now, talking about this habeas corpus. What is habeas corpus? He's calling it the great writ. That is saying, look, you have been detaining me. You have been detaining me, good sir, good police officer, good government agent, whoever it is that's been detaining me, you have been detaining me. I demand habeas corpus. Habeas corpus is literally produce the corpse, show me the body, justify, show me the reason why you are continuing to detain me. It is the right to demand a review of your detention. Literally saying, if you say produce the body, lay it on the court, and show me that my continued detention is justified. I like habeas corpus. All right, let's move on, shall we? Informal consent. Consent given with appropriate knowledge after the person giving consent has learned all of the information that would be reasonably required for the basis of a reasonable decision. In many instances, for an institution or professional to prove that the decision maker was sufficiently informed over a matter to give informed consent, the institution or professional will provide the information requisite to making such a decision in an informed way, but the provision of this information is not a legal requirement to receive informed consent unless a custom, statute, or regulation requires it. Okay, you don't say, Sarah. Oh my Lord in heaven, we've still got 24 pages. Jeebus. Are we at the 2-hour mark yet? Why is time going so slow? We've still got 40 minutes. Why is time going so slow today? All righty. Just stretch. An attorney or other professional has an obligation to provide any person with adequate reading her handwriting. It's literally stressful. It's straining my eyes because we discussed this the other day. She actually has very good penmanship. It's just all scrunched together. And she has these weird breaks in her cursive. It makes reading it really, really eye straining. Okay. All right, let's try this again. An attorney or other professional has an obligation to provide any person with adequate information and explanation of a proposed course of action and its alternatives for the person to know of the material risks of each before consenting. By definition, professionals and fiduciaries have similar obligations to their clients and to those with a reasonable right to rely on their information or advice before consenting. All right, so the to be informed, the lawyer has to say we can do it. We can do A, we can do B. A has these pros and cons, and B has these pros and cons. What do you want us to do? The lawyer or other professional shall, 1, promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules, and 2, reasonably consult with the client about the means by which the client's objectives are to be accomplished, and 3, keep the client informed about the status of the matter, and 4, promptly comply with reasonable requests for information, 5, consult with the client about any relevant limitation on the lawyer's or others' professional conduct when they know that the client expects assistance not permitted by the rules of professional conduct or other law. Legal ethics. Legal ethics, the professional obligation of a lawyer, including those codified by rule and a body of rules and standards of conduct that the legal culture imposes on his members. Ethical standards arise, as does their authority over the attorney from the oath of the attorney. The inherent power of the courts to discipline lawyers before the bench, the culture of the profession, and the standards of liability for fiduciaries and professionals. Under these rules, legal ethics usually require attorneys to avoid conflicts of interest, to practice with diligence, to avoid frivolous, false, fraudulent, or harassing behavior, to zealously represent others, and generally to avoid the appearance of impropriety. A violation of legal ethics subjects the professional to sanctions from the professional bar and courts. Brevier Law Dictionary 2012 edition. What? Seriously? Your stuff is still on the Duress page? That's weird. All right, let me make a note here. We're on page 35. I'm going to close this out and then I will reopen it. All right, see page 35. All right, let me reopen this again because I certainly none of you would want to miss that, right? Certainly your life would be incomplete if you weren't able to follow along reading definitions from Bouvier Law Dictionary 2012 edition, right? But just for you, let's reopen this again. All right. You guys don't know what you've been missing. You've been missing some pretty amazing penmanship. All right. Share screen window. Is it okay? It's moving again. All right. Well, it should be fixed now. Deep sighing turns me on, except when Judge Bev does it. Lol. All right, let's go. No, I don't want to edit the bill. Do that anyway, so we can enable editing. Embiggen. Oh, wow. All right, so let's get down to page 35. All right, still moving for you guys. See, I had my screen covering yours, so for whatever reason, I don't know why it froze, but it did. Let's see. Do we have anything to read? Nope, we're all caught up on the super chats and all that sort of stuff. All right. Good. All right. Just checking to make sure I wasn't missing anything. Here we go. We read legal. Did we read legal ethics? What are we on? Perhaps I was. No. Okay, we're past that. Why did it say 35? Maybe I was stuck on page 35 too. Abusive process. No, we haven't got there yet. Equal protection. Didn't get there yet. Legal ethics. What the hell? This is weird, isn't it? Okay, professional obligations, equal protection of the law. Abusive process. This is weird. Where the hell? What was I reading? Habeas corpus. Okay, I got excited about habeas corpus. Informal consent. Decision maker was sufficiently informed. Okay. An attorney or other professional has an obligation to provide any person with adequate. All right, before consenting. All right. Here we are. We read 1 through 5. All right, legal ethics. That's where we are. Yes, Ms. Jackson. We are at legal ethics. I figured out just as you said that. Island with the $5. Thank you very much, Island. I appreciate that. Island, I know you think this is boring, but I woke up with a migraine, and listening to you read feels like a soft entry into the day. Well, it's always good to go with the soft entry in the morning. You don't want to go for a hard entry in the morning or a good rough entry in the morning. I always want to have a soft entry in the morning. Just saying. And Honey 2000 said, Legal Vices, I sent you a Facebook at they're going to be hearings on the Ocean's Gate Titan implosion. I believe they start on September 16th, I think it is. They start at some point in September, and they're going to go for about a week. And that'll give us lots of Maritime Monday stuff. Yes, thank you very much for sending me that reminder. I believe it starts on September 16th, if memory serves, like September to the 16th to the 24th, something like that. But we'll have some, definitely have a Maritime Monday fodder from that. So thank you very much. Appreciate that, honey. 2,800. All right, let's get on with legal ethics. We can embiggen this once, I think. Even though we're embiggening it, it's still kind of a soft entry. There we go. There we go. We're ready. Let's go. Legal ethics. The professional obligation of a lawyer includes those codified by rule and a body of rules and standards of conduct that the legal culture imposes on its members. Ethical standards arise, as does their authority over the attorney. From the oath, the attorney, the inherent power of we've already read this, but I'm going to read it again. The inherent power of the courts to discipline lawyers before the bench, the culture of the profession, and the standards of liability for fiduciaries and professionals. Under these rules, legal ethics usually require an attorney to avoid conflicts of interest, to practice with diligence, to avoid frivolous, false, fraudulent, or harassing behavior, to zealously represent clients, and generally to avoid the appearance of impropriety. A violation of these legal ethics subjects the professional to sanctions from the professional bar and courts. Equal protection of the law. Each law should treat similarly situated individuals in a similar manner. Similarly situated individuals in a similar manner. Equal protection of the law. Now, see that they tried that and it didn't work with the old, separate but equal stuff. That didn't work originally. They had to work on that a little bit. We eventually got it down. Hi, Straubs. What Strawberry is doing to Yoda is not legally ethical. It's like sitting on Yoda's head, whatever. All right. I don't know, a little bit sleepy. Is she trying to educate the judge on the law? I don't know if she's trying to educate the judge on the law or if she's just really bored and she's just copying shit she's reading like it was a 5th grade book report. I don't know. But let's find out. Similarly situated people, similarly, in a similar manner. Equal protection of the law is one manifestation of the ancient principle of equal justice under the law, and is required in the U.S. Constitution by states under the 14th Amendment's Equal Protection Clause, and by the national government under the 5th Amendment's Due Process Clause. Equal protection requires each law, whether it is a statute, regulation, order, or application of custom, to treat similarly situated people in a similar way. Well, abusive process. The abusive process, in case you were not aware, is a claim for harm from the misuse of a legitimate legal process. A claim for harm from the misuse of a legitimate legal process. This is a claim that can be brought when a pleading or procedure is wrongfully employed for the purpose of harassing or injuring the opposing litigant. Examples include filing a false affidavit. She's finally, we've got some Sarah in here. Finally. Sarah Boone is injecting herself into the process and not just copying and pasting and cutting and transposing. Right here, examples include filing a false affidavit. My arrest affidavit has someone else's information listed and also an N or no for domestic violence. Then sworn to be true and correct by Connolly. Zelle C impeachment document. The lead detective in my case, what other discrepancies have been made in my case? Question mark. Oh my God, finally, we got a little bit of Sarah in the document. Making false claims. See interrogation videos. Oh, Sarah, my dear. Sarah has just learned an important life lesson. She's saying that this abuse of power, this abusive process includes making false claims like were made in her interrogation video. Let's assume for the sake of argument, Sarah, that your interrogation videos did include the police officers making false claims, otherwise known and referred to as a lie. Sarah Boone is now learning, as Lil Bit Sleepy says, cops can lie. It's not an abuse of process if the cops lie to you during your interrogation. Sarah, you've just learned a very valuable lesson. Introducing fraudulent evidence, statements, assumptions, and guesses. Well, again, statements, maybe. Assumptions and guesses are not evidence. Pleading the abusive process requires the movant to prove 3 elements: that the legal process had been initiated properly and with probable cause, the process was subsequently perverted to accomplish an ulterior purpose for which the process was not originally designed, and the perversion caused harm. We're talking about perversion, Strawberry. Wow. We haven't seen Straubs yet. Let's turn the camera over to Strawberry, shall we? There she is. There you go, girl. You go, girl. All right. So we're talking about perversions causing harm. Yes, business would be considered perversions causing harm. All right. Abusive process involves the misuse of a process already legally in place, whereby a party attempts to obtain a result not proper under law. Fair enough. The 2 essential elements of abusive process are an ulterior purpose and a willful act in the use of process not proper in regular conduct of proceeding. Oh, God. It's still going. 21 more pages. Isn't it time to stop the stream yet? Oh, God, 25 more minutes left. 383 people here watching us read Sarah Boone's transcription of definitions from a lesser Bouvier Law Dictionary edition 2012. All right. For those of you that are just joining us, hit that like button and strap in. We're reading dictionary definitions today. Ooh, excitement. The fuck is this? Interrogatory? No. Interrogation. Cross your T, woman. Interrogation. Examination of a suspect. The process of inquiring by which police or other law enforcement personnel seek information from a person suspected of a crime. Star. Interrogation is distinct from interview, as titled on my transcripts, in that the police seek not merely information in general from the suspect, but also statements from the subject that are either directly or indirectly incriminating. This may involve direct questioning or other actions designed ultimately to elicit such an incrimination, and is subject to the due process of law without any compulsion of any kind. Interrogation is a concept, as conceptualized in the Miranda sense, reflects a measure of compulsion above and beyond that inherent in custody itself, referring not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Ooh, isn't that interesting? Well, Duncan, Idaho, who is now paid $5 to hear us read from the dictionary, says, riveting stuff, Jeff. Keep soldiering on. Or if we were in a wood shop or a metal shop, I would say keep soldering on. Yeah, let's keep soldiering on and watch Strawberry lick her paw. Well, we know what interrogation is, but what about custodial interrogation? That's what's coming up next. Custodial interrogation. Interrogation of a person in the custody of law enforcement officials and is following a person's arrest or custody. All right. The hallmark of custodial interrogation is that the person knows that the person is in custody and has no freedom to leave. I did not know I was in custody and could not leave. I was told by Coopsell to come pick up my phone, no warning of being interrogated again. Well, see, that come and pick up your phone, that was the enticement to get you there. Once you go to pick up your phone, and then the good detectives pull you into the room and say, Sarah Boone, you have the right to remain silent. At that point, guess what? you ain't walking out that door. They don't have to warn you you're going to be interrogated. They can just start it. During custodial interrogation, the stakes of interrogation are higher than when a person is free to go, and any statement made in custody during is presumed to be coerced under the Fifth Amendment. What? And any statement made in custody. All right, she's done something wrong here. This makes no sense. During custodial interrogation, the stakes of the interrogation are higher than when a person is free to go. And any statement made in custody during is presumed to be coerced. She's left something out of that statement, so I'm not even going to try to figure out what the hell that means. The constitutional distillate of Miranda. Ooh, the constitutional distillate. I like that. Of Miranda is that self-incrimination flowing from custodial interrogation is ipso facto compelled self-incrimination because of the inherent coercion, the inherent compulsion of the custodial interrogation environment. I don't even know what the hell is being talked about here. What's the... Compelled self-incrimination. What I think is missing from this is that Miranda is designed to prevent this self-incrimination just from being in the custodial interrogation situation, because the custodial interrogation is ipso facto, or just in fact a compelled self-incrimination. That's why they have to read your Miranda rights. They say, look, anything you say can and will be used against you, so you have the right to shut your hole to avoid self-incrimination. That's all right. So yeah, that seems to be what's missing from this, is the fact that Miranda is designed to counter this presumption of inherent coercion in the process. Excited utterance. A spontaneous declaration or spontaneous exclamation. An unthinking statement made at a moment of great surprise and duress. An excited utterance is a statement made during or immediately after the declarant is surprised by a startling event or condition, while the declarant is under the stress of excitement caused by the event or condition. Like, "Ooh, it's a white man," that kind of thing. Sorry, didn't mean to scare you, dog. It's those type of things. Like you're being stabbed. Oh, it's my husband. Things like that. Those would be excited utterances. What the shit is this? Here is a map of the United States. There are stars in some parts of the state. Does Utah? No, Utah does. We don't get a star. Oh, look. If we zoom in on this, right? Where are we at here? Okay, we have to zoom in on this. Here's the bar across the bottom. If we zoom in on the state of Utah, right here is Logan. Right, this top part here, Logan. That's my hometown. That's where I'm from. Right there in Logan. in case anybody was wondering where I'm from, that's where I'm from, right there, Logan, Utah. And I know we've got people here in chat that are next door to me in Brigham City, Utah. And we've got people down here in Salt Lake as well, and other places in between. And the old homestead is right about here in Star Valley, Wyoming, and right about there. So there we go. That's I don't know why. Publicity, exploitation, and saturation. She made a map of places where she knows her case has been publicized. Logan is based. Where's England? I covered this case, says Karen. Weird. All right. I guarantee they've talked about the case in Utah. Come on, Sarah. Yeah, Utah is not exploiting her. Oh, hey, there's a world map here. Don't feel left out, rest of the world. We got Canada, we got Canuckistan up there. Canuckistan has been saturated with Karen, as well as North America. Oh, there you go. There you are, Karen. England is well, actually it appears that England has not been saturated, but apparently the Shetland Islands have been. So you still haven't been accused of being saturated by her case, Karen Cole, unless you happen to be from the Shetland Islands. For some reason, the Shetland Islands have been marked off. What else we got here? Is that the only place? No, Africa hasn't picked up her case yet. Eastern Europe. Shut up! Woo! Oh no, boo! Japan, the Sea of Japan. The Sea of Japan has been saturated with her. Interesting. You can't see it here, but right about where the H is in South, that's where Busan, South Korea is. So yeah, that's I'm right about there where the H in South Korea is. Australia hasn't been in the game, so well, there you go. North America, including the United States and Kazakhstan and the Shetland Islands have been, and the Sea of Japan, otherwise more properly known, if you ask Koreans, as the East Sea, has been saturated with Sarah. What the hell is this? This is so dumb. I'm so weirded out by this. Publicity exploitation and saturation. Sarah not care. No, I'm talking about legal-minded friends Karen Cole. That's who I was referring to as Karen. She's in England. She's in the United Kingdom, at least. I don't know if she's actually in England itself, but that's so Tammy Fayette. Thank you very much for the super chat. When I was saying, don't worry, Karen, I was saying to Karen Cole, legally minded friends, Karen Cole. Got to keep your Karen straight here, Tammy. So thank you very much for that $2, just so that I can prove you wrong. just kidding, Tammy. Thank you very much for that. Lamau. Oh, thanks. All right, let's find out what the hell those two maps were all about. Publicity, exploitation, and saturation. United States map, page 1. To date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. World map 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Slide this over here. Most letters and messages are available for review and understanding of the impact of my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment. Before my trial, I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. Incorrect. We've seen parts of it, but not all of it. It's because we get to watch TV. The Constitution, or the continuation of the obvious exploitation, allows the world to keep pressing their incorrect, presumed, unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. Oh, sorry. My present attorney said it is not necessary to receive a court order I've been trying to obtain to download my case information to apply from the OCCD tablets. Your attorney is correct. It's not necessary to receive a court order. The prosecution has a duty to turn it over to you. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Well, okay, if they've been lost, they're not really withholding them, are they? They shouldn't have lost them, but if they have actually been lost, they're not really withholding them from you. They just don't exist anymore. Been lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I am missing innumerable case items, which I continually request to be returned or obtained without success. Invasion of privacy, Supreme Court, wrongful conduct. More dictionaries. We get more dictionary definitions. Make it stop. Make it stop. Time for another drink of water. We have 14 pages left. We're just going to soldier on through to the end, I think. I would hate to inflict you with another day of this. This is rough. I'm doing some math here. All right. Never mind. We are still far away from the unlocking achievement number 2. So I won't even worry about it. Intrusion, appropriation. The unlawful use of a person's name or likeness to obtain some benefit. Yeah. So what? If you're saying someone is appropriating your name or likeness, say it. Don't just quote the dictionary definition. Intrusion, physically or electronically intruding into one's private quarters. Has that been done? If so, please elaborate. Public disclosure of private facts. The dissemination of truthful private information which a reasonable person would find objectionable. 4. False light in the public eye. Publication of facts which place a person in a false light, even though the facts themselves may not be defamatory. Defame is starred. To injure or destroy the reputation of by libel or slander. Anything is defamatory if, quote, it has the tendency to render the party about whom it is published contemptible or ridiculous in public estimation, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. And yes, perhaps this is meant to dissuade virtuous men from associating with her. An opinion can be actionable if it implies the allegations of undisclosed defamatory facts as the basis for the opinion. Well, thank you very much. Dude, Luke, no. Invasion of privacy, false light. Publicizing some matter to create a false and harmful impression. False light is both a theory of invasion of privacy and, in some jurisdictions, an independent cause of action, arising when a person, 1, gives publicity to a matter concerning another person that places the victim before the public in a false light. Well, that doesn't apply to you because regardless of what you may or may not think, Ms. Boone, you are not the victim in this case. Poor old innocent, wafer thin, whisper thin George. George is the victim in this case. So 1 doesn't apply to you. 2, that would be highly offensive to a reasonable person. Sorry, this isn't highly offensive to a reasonable person. 3, when the persons giving or creating the publicity either had knowledge of the false light that would result or acted in reckless disregard of the falsity of the publicized matter or the false light in which the other would be placed. In order to state a claim for false light invasion of privacy, the person need not prove that they have been defamed. Rather, it is enough that they are given unreasonable and highly objectionable publicity that attributes to their character, conduct, or beliefs that are false, and so is placed before public in a false position. Well, first, it has to be false. So, and quite literally, the jury is out on that question. The line is drawn when the publicity ceases to be giving of information to which the public is entitled, which is kind of what we're doing here, and becomes a morbid and sensational prying. Oh my, look, she's gotten artistic. It almost looks like her advertisement for a lawyer sign. Oh, God, my neck is getting sore. Publicity, exploitation, and saturation. My personal individual criminal case. Oh, good. She's going to tie it all together for us now. She's going to wrap it up in a nice, sweet little bow for us. She's going to, see, all these, she says the word taint down there. How saucy. She's putting all of this together now. All of this. She likes underlines. We're going to get, this is the conclusion. All right. My personal individual criminal case is being advantageously exploited and abused from all of my significant life-saving suppressible case details. Evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission in any form, written or verbal, to anyone, then broadcasted, distributed, and hand-delivered to the entire planet, states, countries, continents, containing all of my potential jurors. There are no potential jurors for your case in Japan. There are no potential jurors for your case in the Shetland Islands. Just letting you know that. containing all of my potential jurors, causing irreparable, erroneous falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, ideas. This is not like open mic night at the Beat Poet deal. So make your words make sense, please, Karen. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. A misprejudgment. I don't think that's a word. A misprejudgment has already been made unfairly against me from the undeniable violation of my constitutional rights and due process of law. The violation of your constitutional rights and due process of law might be deniable. I wouldn't go so far as to say it's undeniable. As a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage and free from all partiality, deceitfulness, and dishonesty made from said evident exploitation. Definitions collected from Bouvier's Law Library, Merriam-Webster's Dictionary, Smart Communications Tablet. Thank you very much. Oh, here's all right. Some more definitions for you. Before we get going, Luke Smith is repenting for his remarks with a $5 Australian super sticker, a pair, saying ha ha ha. Thank you, Luke. Appreciate it. Oh dear. Did I miss her addressing subject matter jurisdiction? Not yet. Oh dear God. I hope she doesn't meet any sovereign citizens in jail. That would be bad. Flux says, ha, taint. Stop tainting me, Vice Daddy, says the content lasagna. All right. All right. Settle down, everybody. Settle down, you frisky people. Because we've got some definitions to read here. Exploit. To fairly or irrationally use the fuck? Hang on. Someone's at my door. The hell is that? That's really odd. That's okay. There's someone that rang the downstairs main doorway. Nobody was on camera when I went to look at it, so they got in somehow. I may be having an unwanted visitor here. This is weird. It's midnight. Okay. It's exactly midnight, which was weird. Exactly at midnight, the bell rang. All right. Well, shit. Well, maybe they rang the wrong bell, but then how would they get in? This is weird. All right. Whatever. It's Buchanan. No. Yeah. Don't open the door or you'll let the spirit in. All right. Well, I got a good tripod here that's attached to Doggo Cam, so whatever. All right. Well, nobody's come in the house yet, so all right. I'm assuming it was just a drunk neighbor. All right, let's continue, shall we? If I suddenly go, you'll know it was somebody that snuck into my house. All right. Exploitation means an unjust. What the fuck is going on? Strawberry just made a dash for the door, but now it's just stopped in the middle of a dark hallway. They don't do swattings in Korea, so I know that's not it. Plus, nobody knows where the hell I live. All right, that was just really weird. Huh. Yeah, he can't strap up, right? But I'm going to be seeing something because Drunk Me over the weekend ordered a double-headed Viking two-handed battle axe. So I'm about to see if that'll somehow make its way through customs within the next couple of weeks. But it'll arrive 2 weeks early, 2 weeks late, apparently. All right, weird. I have no, it's Donald Hartung. No. All right. Well, I have no fucking clue what that was all about. So let's continue. That was just weird. Exploitation means an unjust or improper use of the resources of a vulnerable adult for the profit or advantage, monetary or otherwise, of a person other than the vulnerable adult through the use of undue influence, coercion, harassment, deception, false representation, or false pretense. It's coming from inside the house. It's the Sonny Chu medallion arriving. Oh no, that would be hilarious though. Battle axe, is that what they're calling marital aids now? No, that's what they're calling the spouse. Anyway, all right, abuse, a corrupt practice, to put to a wrong use, to misapply or misuse, to pervert application to and for a wrong purpose. Significant. Oh my Lord in heaven. No. She is going to give us the definition for every goddamn one of these underlined words. I just realized that's what she's doing. Exploited, abused, significant. Oh no. We have to read the definitions for every one of these words. Oh no. Suppress, the restriction of a person's action or speech, to keep from being known, to stop the publication or circulation, to hold back. Oh my God. Illegal, not lawful or sanctioned by official rules, not according to or authorized by law. Illicit. Coerce, to restrain, especially by law or authority, to repress, to compel or constrain to any action as to coerce someone to vote for a certain candidate. Trickery. Come on, I need a refresher, says Chloe Albert's Revenge. English class has begun. Trickery, deception by trick and stratagems. Fraud. Duress, the state of compulsion or necessity in which a person is influenced, hardship, pressure, constraint. Constraint seems to be coming up a bit here. Confusion. That's what I am right now about what the hell happened on my front door. Confusion, to make mentally unclear or uncertain, to disturb the composure of the state of being mixed or blended to produce indistinctness or error, to cause or make disorder, tumult. Broadcast, scattering in all directions, to spread widely, to feed the geese, to make widely known to or over a wide area. The transmission of sound or image by radio or television, cast or dispersed in every direction. Distribute, to divide among several or many, to deal out a portion, a lot, or to spread out. All right. Deliver, to send to an intended target or destination. So stupid. Convey, transferred, to release, to give or yield possession or control of, to make over to the knowledge of another, to give forth in action or exercise. Irreparable, impossible to make good, undo, repair, or remedy, not repairable, not capable of being recovered, regained, irretrievable. Erroneous, incorrect, wandering, straying, deviating from the right course, misleading, mistaken. Oh my God. falseness, not genuine, artificial, intentionally untrue, adjusted, or made so as to deceive, tending to mislead, inaccurate, based on mistaken ideas, contrary to the fact, double dealing, perfidy. Perfidy is actually a very good word. I like the word perfidy. Perfidy needs to be used more. Taint. Please be in the definition of taint. Please. Corrupt, contaminate, to affect or become affected with something bad, a contaminating mark or influence, to imbue with something extraneous, especially with something poisonous. Boo. Apparently she didn't consult the Urban Dictionary while she was reading through other dictionaries. That would have been hilarious. Force. Strength or energy of an exceptional degree, active power, capacity to persuade or convince, and influence that causes motion or a change of motion. Influence. It's like the gooch, right? Yes, it is. It's like the gooch. Exactly. Influence, the act or power of producing an effect without apparent force or direct authority. The power or capacity of causing an effect in indirect or intangible ways, to sway, to have an effect on the condition or development of, by a gradual process, whatever that says. Controlling power quietly exerted. Incorrect, not correct. In case you didn't know, incorrect apparently means not correct. Not according to established rules, inaccurate, faulty. Neat in accordance to a copy, or needed, or testimony not true, wrong. Come on, work on your... How can her penmanship be so good and so bad at the same time? Inappropriate, fitted to a wrong purpose or use. I guess her hand is probably starting to cramp up about now. I guess that's probably what's causing her to become less legible than usual. Her hand is cramping after 50 pages of definitions and transcriptions. Motive, something as a need or desire that causes a person to act, that which produces conception. Motive doesn't produce conception. I'll tell you what produces conception. Invention or creation in the mind, a guiding or controlling idea of or relating to motion. Invade, a warlike or hostile entrance into rights, possessions, or domain of another. Trespass, to enter for conquest or plunder, to spread through and harm. Privacy, the ability, or the quality or state of being apart from others. Secrecy, a place of seclusion from occupancy or observation. Oh my God. Oppression, hardship, or injustice, to impose excessive burdens upon, to overload, to treat with unjust rigor or cruelty, to crush by abuse of power or authority, to weigh down, persecute, wrong. Oh my God, I can't believe there's 390 people of you listening to me read Sarah Boone's transcription of dictionary definitions of words. And I can't believe I'm doing it. So let's suffer together for a few more minutes, shall we, people? Once more into the breach, to quote Henry V from Shakespeare. Deplete, to reduce by destroying or consuming the vital power of, the exhaustion of strength or resources, to empty or unload. Unload and the taint. Entitle, to give a right or claim, to qualify for, to furnish with grounds for seeking or claiming with success, to attribute or ascribe. Been there, done that. Says, who said we were listening? Fair. Conforming with the rules, free from obstacles or hindrances, unobstructed, characterized by honesty, impartiality, without any suspicion, bias, any marked characteristic. Whatever. Proper, marked by suitability or rightness in all aspects, appropriate, excellent. Successful. Oh my God, do we have to do this? Resulting in success, accomplishing what was proposed, favorable or desired outcome, the result of an undertaking, endeavor, or effort. Prejudgment. to judge before hearing or full and sufficient examination, to decide or sentence by anticipation, to condemn beforehand. Unfair. Reading this is unfair. It's unfair to you. It's unfair to me. And oh my God, more people are coming here to listen to me read definitions that have been transcribed from dictionaries by Sarah Boone. Unfair, marked by injustice, partiality, deception, unjust, not fair or honest, disingenuous, using or involving trick or artifice, unequal, undeniable. I wonder if we can like make this sound like, let's see how much of this we can make sound like really dirty and salacious, shall we? Like the old Monty Python skit, like, you know, offensive words. Wankle rotary engine. Undeniable. Plainly true, incontestable. Unquestionable, not deniable, indisputable. No, that didn't work too well. Violate. Ooh, we can do it with violate. Violate. Break. Disregard. Interpret or disturb, to abuse, infringe, non-observance, the violation of law or positive command of covenants, promises, anything that should be held sacred or respected, and the contemptuous treatment of. I keep having to like check messages to see if it's someone going, I'm trying to break into your house. Where are you? Constitutional rights, the rights protected under the Constitution of the United States of America, and the most contemporary sense of right, which implies a greater emphasis on the idea that the right is conferred upon the person by the Constitution, and without a Constitution, the person would have no rights. The enforcement of constitutional rights is a matter not only for courts, all branches of government also. Liberty right, the constitutionally protected ability to engage in certain conduct or hold a certain status, and in doing so, to be protected from interference by police or other agents of the government, unless that interference is well justified and legal. The right to privacy and freedom of speech are examples. Privilege, or positive right, sometimes called a claim right. 5 more pages, people. 5 more pages. I'm out of water. Sometimes called a claim right, the constitutionally protected ability to call upon agents in government to assist in performing certain conduct or to hold a certain status, and in doing so, to be protected from interference by other government agents and by private parties. Private parties, man. Procedural right, the constitutional requirement enforceable by the citizen that the agents of government act only in certain ways, according to certain rules and in consultation and agreement with one another. The rights to laws made according to specific procedures, to trial by jury, and to be free from torture are examples. Well, by God, I am being tortured by having to read literally 40 pages of definitions this evening. Oh my God. Fundamental to all these rights is a constitutional right in each individual that the agents of the government will abide by the Constitution and do nothing through the power of the state that is not allowed to them to do by the Constitution. The right not to be taxed for an unlawful purpose is an example. I would like just the right not to be taxed, period. But hey, you know, constitutional rights in life says this is what due process is. Oh my God. Constitutional rights in life, liberty, and property interests that cannot be burdened without due cause or appropriate procedures. Due process of law is a fundamental aspect of law, including not only the process by which laws must be created and applied, but also the scope within which certain laws must be made and enforced, and beyond which laws ought to leave individuals to their own liberty. The Due Process Clause of the 14th Amendment prohibits state government from depriving any person of life, liberty, or property without due process of law. Thus, due process of law includes both a procedural and substantive aspect. Oh, Christ. Procedural due process. I can't do this. I can't do this. I want to quit. D, what is helping us along the path of righteousness by gifting 5 more Legal Vices memberships. Let me get the foghorn out. Thank you, D. What, with 5 more Legal Vices memberships. Becca has thoughts. You got one. Big Al got one. Crystal Johnson got a membership. Lisa Bates Lester got one, and so did A Job Done Well. You all got memberships gifted by D. What. Make sure you give D. What a super special thanks. Don't give up, Jeff. The shame of being beaten by Sarah Boone will haunt you. I know. I'm like the guy that's just, he's dehydrated and he's out of his mind and he's just going across the end of the marathon line, and hopefully one of his teammates will stop and put him over their shoulder and like help them cross the finish line together. That's kind of where I am at this point. You know what? Burning sensations, I fucking agree with you. I do deserve a shot of whiskey. I'm not going to do just a straight shot, but I will have a bit just due to the lack of water. This is the Woodford Reserve Korea edition. I'll take it just a small sip. Oh my God, my throat is so dry. That's just like caramel flavored acid. It's really, really good. And normally it would be awesome, but my throat is just stripped dry. Oof. All right. It's putting a coating on my throat.
Hey, phrasing.
All right. Whew, that's some good bourbon. Yum. Procedural due process. Procedural due process rights are meant to protect persons from mistaken or unjustified deprivation of life, liberty, and property, and entitles a person to an impartial, disinterested tribunal in both civil and criminal cases, protecting 2 central concerns: the prevention of unjustified or mistaken deprivations, and the promotion of participation and dialogue by affected individuals in the decision-making process. Haschick says, don't go all Ricada on us. I'm going to do my damnedest not to. I only have whiskey in my house. Substantive due process rights are those fundamental rights. Okay, we read procedural due process. Now we've got this substantive due process. There'll be a quiz later. God, this is like my worst day in law school. I swear to God, this is like my worst day in law school. This is the shit I would be taking note. Oh my God. Substantive due process rights are those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition. They are rights implicit in the concept of ordered liberty. I have no idea what that word is. What estate or condition shall be put out of land or tenement? No man of what estate or condition shall be put out of land or tenement, nor taken. She does this, like her O's look like double E's. Like if you look here, this is the word nor. It looks like N-E-E-R, but she makes this double loop for her O's, and it is distracting as shit. You can see like objective, conception, condition of, nor taken, nor imprisoned, disinherited, put to death without being brought to in answer by due process of law. You're making it our worst day too, Legal Vices. Well, there you go. Just sharing the horror with you. The horror. Just sharing the horror with you. Analysis of either a procedural or a substantive due process claim must begin with an examination of the interest allegedly violated, and the possession of a protected life, liberty, or property interests is a condition precedent to any due process claim. Publicize, to bring to public attention, to advertise. Rightful, having the right or just claim according to established laws. Belonging, held or possessed by right. consonant to justice. All right. Lawful. There's another big round word. Lawful. Lawful. Permitted. Constituted. Or authorized by law. Big round words. Full round words. Rightful. Legitimate. Competent. All right, sorry. Enough of that. Ethical, conforming to accepted and professional standards of conduct of or belonging to morals, treating of the moral feelings and duties according to in harmony with natural principles or characters. Island with the $2. Do one definition in the whisper, pretty please. Oh, you want an ASMR definition? All right, we'll take requests here for the last couple of pages. So you have to anesthetize the throat here for this one. Okay.
Phrasing.
Disadvantage, an unfavorable, inferior, or prejudicial condition, quality or circumstance, unequal. A position, an unequal position in society, loss or damage, especially to reputation or finances. Partiality, inclined to favor one party in a cause or one side of a question more than the other. Biased, not indifferent, having a predilection for, inclined to favor unreasonably, special taste or liking. Special taste. Deceitful. Oh, we're so done. Of course, the last page is a full fucking page too. It's not even one of those like 3 lines on the page. We've only got 3 full pages left, people. Bear with me. Let's stick this out. We've got to stick our landing. Deceitful. An attempt or disposition to lead into error, any trick, collusion, contrivance, false representation, or underhanded practice used to defraud another. Fraudulent, causes to believe what is false, entrap, seduce by artifice, misled. Did we do partiality? I don't think we did partiality, did we? But you know what? I guess we did, because the word predilection. Dishonesty, void of integrity, faithless, disposed to cheat or defraud, violation of trust or of justice, untrustworthy, want of fairness, to betray. Evident, clear to the vision and understanding, satisfactory to the judgment, apparent. Excited utterances are admissible. Oh, she forgot to underline excited utterances. Dismissed. Excited utterances are admissible evidence despite both the hearsay rule and confrontation clause, because they are only admissible when the circumstances of the statement are sufficient to demonstrate that the statement was an unthinking, unplanned reaction to events. To introduce an excited utterance, the proponent must demonstrate that the statement was made during or following a startling event or condition, that the statement was made while the declarant was under the stress of excitement caused by the event or condition, and the statement relates to the startling event or condition. The manner in which the excitement is caused may be direct. We should do this in the Dr. Ruth Westheimer voice. The manner in which the excitement is caused may be direct, as when the declaration is a participant in the event or a witness to it, or indirect, as when the declarant learns of the event later. Sorry, we'll never do that again. By definition, a statement may be an excited utterance and not perfectly contemporaneous with the event, but it must be made while the emotional state caused by the event or condition persists. Many, though not all, statements that are excited utterances are also forms of statement or present sense impression. Yes, Rip Dr. Ruth. Dr. Ruth passed, what, about a month ago now? It was like she was in that rash of people dying a few months ago. Donald Sutherland and Ruth Westheimer and like everybody else in Hollywood that died. Coercion. Ladies and gentlemen, this is the last page. We have reached the very end. This is it. The very end, my friends. Coercion, unlawful force, fear or threats used to spur another to conduct. It is in the influence, compulsion, or restraint that diminishes free will and causes them to do or to refrain from doing anything. It is the basis for the crime of criminal coercion, which is a form of blackmail. The Freedom of Information Act, FOIA, FOIA. So Uncle Roger says this letter sucks ass. I've lost my damn mind. This has broken me, people. A federal or state statute requiring governmental agencies to release information on request. It is a statute that requires the dissemination of information held by government agencies through regular publication of such information or by the release of such information only by request. The 9 categories of government information exempt from Freedom of Information Act are, sorry, children. Exactly. Uncle Roger, sorry to the children. Oh, good. She only lists number 7, apparently. Law enforcement records records if their production could. Now, these are the things that are exempt from the Freedom of Information Act, that you cannot get through the Freedom of Information Act. Law enforcement records if their production could reasonably be expected to interfere with enforcement proceedings, to deprive a person of a right to a fair trial or impartial adjudication, to constitute an unwarranted invasion of personal privacy, to endanger the life or physical safety of an individual. That's it. This is what we used to call in the radio DJ business a cold out. It just ends. Like Steve Winwood's song when it goes, the same boy I used to be, and it ends. That's a cold out. This was a cold out here on the on Sarah Boone's letter. No dear, no best regards, no all the best, no go fuck yourself, nothing. It's just, this is the end of my letter. It's a cold out. All right. Speaking of cold outs, good God. That was not how. When the hell did my dogs disappear? All right. No, I'm never going to do the Dr. Ruth voice ever again. It was a sign of weakness. It was a sign that I was being broken. All right, people. Oh my God. I have no idea what this last 2 hours and 28 minutes was for. There was literally 3 or 4 sentences that were her own thoughts. The rest were copied from dictionaries. Oh my God. I am so sorry to everyone that had anything to do with this show today. I was really hoping it would be interesting and she would be all over the judge and, saying salacious and annoying things, but good God, we just read definitions for 2 hours and 30 minutes. Duncan, Idaho with a $5. Thank you, brother. Who knew all she needed to do was get imprisoned in order to tap into her genius and break new legal ground by reminding the court of definitions. Oh my God. Let's see. Now, the last thing we'll do here is this stupid advertisement she did for a lawyer. All right, I got to find it. Let's see. There we are. Then I need to open in a new tab. Copy from Chrome over here to Edge. What do you mean the page can't be found? All right. What if we open the image in a new tab? Will that help? Nope. God dang it. What if I go to Twitter? Sorry, folks. Bear with me for just a quick second. La 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 la. And go to where I've been sent. Island sent me this. I think she was the first one to send it. So let's go here to open image in new tab. Embiggen. All right. This was after, I'm sure most of you have seen it, but after she was told that she no longer gets her 9th lawyer, she made an advertisement. She made an advertisement for a new lawyer. I guess she's going to put it on the classified section of Craigslist or something. I don't know where she plans on putting it, but inmate seeks attorney. It's like, the Craigslist things. Inmate seeking attorney. Looking for a prosperous challenge? Now, this is one we can read in a salacious voice. Ready for your close-up on international television? Are you zealous with a side of keen? Show the world who you are with your original creativity, your extraordinary expertise. For just $19.99, you can show the world your confident ingenuity. Qualifications must include, for just 99 cents a minute, you can be trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing the winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently and overcome all circumstances. Epic opportunities await. Sarah Boone, number 20005623, Orange County Corrections Department. Invest in the oppressed. Believe. Shh. How's that? That's the advertisement that she's putting out to the world for her new lawyer. Good Lord. Okay, Jeff, stop. This is cringe. I didn't write it. I'm just reading it. Kurt needs to nut up and defend her. That's funny. All right. There we go. There's the cringe for today. That was the only way to get through that because it's just a stupid advertisement. All right. There. Y'all got what you wanted, Jeff. You're scaring the children. Nicola Maxwell says, we're trauma bonded. I literally laughed really loud. She should post in the jail cafeteria message board since she can't go public. I seeks a. Inmate seeks attorney. Oh, dear. All right. Everything about the Sarah Boone case seems off. Her detachment from reality is hard to believe. P.S. I won't kill you. I thought she was representing herself. Well, she is because she can't afford another lawyer, and they're not giving her another freebie. So this is her advertisement. That was her advertisement seeking a new lawyer who will take her case. This wasn't an appeal to the court. This was like a legitimate advertisement she was putting out there for another lawyer to represent her in this case. So yeah. All right, everybody. I've lost my mind. I'm broken. I'm just an empty husk of the man I used to be. Sarah Boone has has effectively put me in a suitcase and ruined me for tonight. So let's see. Let's find out where we can send you. I'm sure someone's doing day 798 of the YSL trial or whatever that is. I know Nick Staro's not doing it because he's on his way to America right now for his little old vacation. Let's see. Here's our show for today. Go to customization and redirect. All right. It looks like Cat Not Williams is where we're going. We went to Cat Not Williams yesterday. Looks like we're going to go there again today. So before we take off, before we wrap this up today, tell the 317 survivors that are still here. Tomorrow, thank God, is the Donald Hartung murder trial, part 11, I think. And again, if you missed the first 10 parts, it doesn't matter. With all good luck, if there's any luck on our side at all, we will get the Wiccan high priest on the stand near the end of tomorrow's show. So we'll see if we don't get to the Wiccan priest at the end of tomorrow's show, we'll get there for sure at the beginning of next week. Porcelain Thunder knows. Porcelain Thunder with the that's the Donald Hartung trial. Tomorrow we'll be doing that at the normal time, 9 a.m. Eastern time. And on Friday, not a clue what we'll be doing yet. Hopefully they'll be showing the Karen Reed trial live. If they do, that's what we're going to be doing. If not, then there will be no Friday show. I mean, Friday morning show. We'll just do a rebroadcast of it when it's uploaded, hopefully on Friday evening. So there'll be something either Friday morning or Friday evening. Stay tuned. Just watch your Twitter feed and make sure you are subscribed to the channel and you sign up for the notifications. And hopefully YouTube will actually give you a notification. All right, let's look at our poll. How did our poll and our like and subscribe poll? This is your last chance to hit that like button. We've got 435 likes. And to subscribe to the channel, or to make sure you're still subscribed, the poll today, Sarah, 9% of you said, Sarah, avoid danger and danger of suffocation. 13% of you said, Sarah the Roach. I can't even do the singing part now. Suffocation, no breathing. That's the best I can do. My voice is hammered. And 14% of you said Sarah should have killed him. Smother time. And with 65% of the vote, Sarah had a prison nickname, Smotherfucker. There you go. Mm-hmm. All right, that's it, people. Why would I team up with David Gingras to be Sarah's lawyer? What did I ever do to you, Jennifer, that would make you suggest either one of those scenarios? All right. Anyway, people, mods, thank you so much for being here and doing your moddy wonderness. It's deeply, deeply appreciated. Thank you so much for the membership gifts, the purchase memberships, the super chats, all the support you guys gave. We have a 2-day streak with the emotional support potato pig dog cam. Thank you so much for just being here and keeping each other company through this painful time. There was the reading of definitions by me. Thank you very much. We'll see you tomorrow for the Donald Hartung trial. Good night, everybody. Bye. You know what? I'm still getting these. You're using Karen and Sarah. No, I was talking to legally minded friend Sarah. See, now I did it. Karen Cole about the ubiquitousness of the case. I wasn't using Sarah and Karen interrelatedly. I was talking to Karen about Sarah. Now with that, that's the last time I'm going to talk about that. Goodbye again.